not unless they're going into my phone.
Wow. Testing.
All right, I'm going to send it to you.
Okay.
Good speaking voice, Tamara.
Testing, testing, testing.
Check 1 2, test 1 2.
testing, testing. I'm Tamara Favorito, and I want to welcome you to VoterGA's press conference. Today, once again, we will be focusing on Fulton County, Georgia. Garland will first present his state election board complaint that he's filed against Fulton for claiming they did not have the ballots that were just recently seized by the FBI. Then he'll talk about how the Fulton County plaintiffs opposing the FBI search warrant have no standing to do so. And then finally, he'll walk through much of the evidence supporting the probable cause presented to a magistrate judge to obtain the search warrant for the Fulton County elections hub and warehouse. Then I'll come back and talk a bit about VoterGA, and then we'll go to questions and answers. We will be taking questions on today's topic, and we are streaming on several platforms. So if you are watching online and you have a question, make your way to Rumble or X and put your question in the chat, because we'll be monitoring those two platforms. And then we'll come back up. I'll conclude with an update on Tina Peters, as we have done for a little over a year now. We'll show you a video that is a tribute to her 500 days in prison. And then, as always, we'll pray for her. So with that, I'd like to introduce Garland to you. He's a career information technology professional with over 40 years experience, including 13 years of cybersecurity protection for over 1.5 million online banking customers. He also has 25 years of voting system technology and election integrity advocacy. In 2002, he was the first technology professional in America to advocate against a statewide implementation of a paperless electronic voting system on the grounds that it posed a threat to our constitutional rights to vote. His claims were upheld 17 years later by a U.S. District Court who ruled that Georgia's unverifiable voting system was in fact constitutionally deficient. But the fight for fair and honest elections continues. With that, I'll turn it over to Garland.
All right. Thank you, Tamara. All right. So as Tamara said, we've got 3 things on the agenda today. We're going to go quickly through all 3. The first one, we're going to lead off with the complaint that I filed, I guess it was Monday a week ago at the State Election Board against Fulton County. Because as you heard Tamara say, they have told me 4 times they didn't have the ballots that the FBI seized. There's something wrong here, and I'm going to walk through that. They didn't just tell me that. They officially replied 4 times. So as you can see, there is the where the FBI executed the search warrant, and that's the Fulton County warehouse. Thought you might get a little perspective on what happened there. We were down there that day. As soon as we heard about it, we ran down there to take a look and see what happened. But before I get into our complaint, there's a couple things that you need to understand. Number one is, all the way back on 2021, we had, through our lawsuit, on December 23 of 2020, we got active court orders to preserve and unseal the ballot. Active court orders to preserve and unseal the preservation order. We actually went to court on January the 6th of 2021, the infamous date. and then we got the actual preservation order the next day. On May 21st, the judge said that he offered to unseal the ballots. We were in the process of getting it. Then he said we didn't have standing. We went to the Georgia Supreme Court. We won. The case was suspiciously routed back to Judge Robert McBurney, who's ruled against us as we anticipated, and that is still under appeal right now, and we fully plan to win that. So the other thing we have to know before we get into this complaint is we have to understand that the ballots are only required to be sealed for 2 years. Here's the actual statute in Georgia, OCGA 21-2500. It says that they have to be sealed for at least 24 months, not forever, and that they shall be presented to the grand jury for inspection. Such ballots and other documents shall be preserved, and then they may be destroyed. This is the law in Georgia. It's always been the law. So at least since I can remember starting in this. And so that's a couple of things you need to know. The law only requires sealing for 2 years. The unsealed order was in place and the preservation order was in place at the time I filed my first series of open records requests in 2024. So I filed to the Board of Registration Elections in Fulton County. Here you see it on July 10th of 2024. I filed this open records request in the Fulton County portal. They replied, Mariska Bodison replied, "There are no responsive documents to your request." I asked for a copy of the Fulton County 2020 election ballots. That's exactly what the FBI picked up. At least that's what the commissioner, all the commissioners, not all of them, but most of them, the chairman said that they picked them up. The commissioner said that. The clerk said that the FBI picked up the ballots, but yet they told me they never had the ballots officially in open records request. Didn't stop there, so I thought, well, maybe I'll just check the clerk out because, they like to play the shell game between the clerk and the Board of Elections. So I filed the same thing with the clerk. Now, this wasn't easy because I had gone through the portal, and after several months, they said, well, no, the clerk doesn't respond to the portal. So I thought, oh, okay, well, long story short, Tamara and I had to go down and personally deliver the open records request to the clerk's staff at the office. And I finally then followed up with an email, and I finally got a response November 15th of 24, and it says, no such documents exist. Now, they said that because I requested to have them copied, as I always do, in a 600 DPI format, and what we call 16-bit color, which ensures that you could detect a counterfeit ballot, just in case y'all know. And they said, well, we don't have the documents in that format. Well, you're supposed to copy them. Under open records request law, you have to provide a copy, but they just blew me off. They didn't even want to provide a copy in any format whatsoever, which, again, is a violation of open records request law. We'll show you those statutes in just a minute. So the next time, we spent 4 years at the legislature, and we got the election bill transparency law changed and ballot transparency law to ignore 21-2500 and require every superintendent and or clerk in the county, in the state, to give up the ballots if requested through an open records request. It took us 4 years to get that law passed, but we finally got it passed. And I think that was originated with Shaw Blackman, I believe, down in the Macon area, Warner Robins area. So the new law then went in effect January 1st, 2025, said that the superintendent, which is the Board of Elections, that's the official name for the Board of Elections in Georgia law, the superintendent shall produce digital scans of the requested ballots. And they even said at a resolution of no less than 600 dots per inch, and deliver such scans to the requester. that is concrete law. We got it to supersede 21-2500 because they were trying to claim that that means it stays on forever. Well, the law says, notwithstanding any seal provided by Code Section 21-2500, such official or office that maintains such requested ballot shall provide the superintendent access to such ballot without the need for obtaining a court order. So this is the instructions to the clerk, and this is the instructions to the superintendent. You will give up the ballots under open records request. That is the law in the state of Georgia, and that is the law, another of the laws that Fulton County defied. So I submitted the request January 15th of 2025 for the same ballots that the FBI apparently sees that they claim that they gave over. And they told me, again, there are no responsive records. We don't have any. So, and again, they try to use this same excuse for this of the clerk. The clerk does not maintain the ballots in that order. Well, okay, just give me a copy of the ballots. So therefore, there's none. And we're not required to produce records in response to a request if such records did not exist at the time of the request. Well, the ballots existed at the time of the request. So again, they're trying to circumvent open records request law. So they said and besides, they said that the new law doesn't apply to us. I said, okay, well, let's go to the Board of Elections because the new law clearly applies to them. They are required to get the documents. And what did they say? They told me there are no responsive documents to your request. 4 times Fulton County officially lied in open records request to me, and that's all the documentation and all the proof that any court or any state election board needs. So what are the laws that Fulton County violated 4 times? They violated OCGA 21-585. That cites penalties for refusal by the superintendent or his or her employee to permit public inspection of documents, removal, destruction, or alteration of documents. And that is what we're trying to do. We want a public inspection of the documents, and they would not allow that to happen. They also lied, as you can see, in their official capacity, so that could be as well a violation of OCGA 161071, which cites penalties for false swearing in an official capacity. Then you have the code sections, OCGA 501871. That is the open records request law in the state of Georgia. It's been that way for decades, ever since I remember. It requires all public records to be open for personal inspection and copying, unless they're in an exempt list, and ballots and election records are not in the exempt list in 501872. They never have been. And that is why most all the other counties will gladly give up their documents. So they want to charge for them, but they will give them up. There is no dispute by any other county of the 159 in Georgia that they're required to give up the ballots when an open records request is filed. So the statutes in Georgia, OCGA 21-272 and 73, requires those primary election records to be open to the public and to be preserved. And then finally, this is also a federal violation because 52 U.S.C. 20701 requires all election records to be preserved for 22 months. So this is, I think, an open and shut case. It's another a whole nother episode in the continuing 5-year saga of simply trying to get ballots to look at because the election results are not adding up. And we know that is why Fulton County has hid those ballots from the voters in Georgia for 5 years, because they will not add up to the election results that they certified on December 3rd of 2020. So moving on from that, I wanted to switch gears and talk a little bit about the FBI search warrant, which you saw being executed in the original slide. So this search warrant is based on an FBI affidavit we're going to talk about. It's an affidavit of probable cause which was submitted to a magistrate judge, and the magistrate judge signed off on that and saying, yes, so that's obviously probable cause. And we're going to go through a little bit about what was in that. The magistrate, they did go back and reissue that warrant once. Everybody says, oh, is something defective about it? Well, not really. They just simply wanted to narrow the limit scope of search to the clerk's warehouse. If y'all are not familiar with the warehouse in Fulton County, the clerk has a certain area of the warehouse. So they went back and narrowed that search so that there could be no confusion about what it is they were looking for, because the clerk is the custodian of those ballots and election records. Now, the affidavit that they submitted easily outlines provable civil violations. I'll show you that in just a minute. That's their the original cover sheet. The only thing left to know is that the DOJ has got to determine if these violations are a result of criminal intent. Right now, they're just civil violations. So Fulton County didn't really want to give up the lawsuit, so Chairman Rob Pitts and Fulton County, give up the ballots. So Chairman Pitts filed a lawsuit, it's now known as Pitts v. U.S. It seeks to have the FBI return the ballots to them, and don't look at those ballots while you've got them. They do not want them to look at the ballots. Why would they not want them to look at the ballots while they got them? So the plaintiffs of this are Chairman Rob Pitts, the county commission, the county election board. They added the county because they were worried about standing. I'll explain that in a second. And now just recently they have added the clerk, Shay Alexander, who was pressured to go on this lawsuit, even though she has insisted correctly that she is a neutral party as a custodian, and she has been pressured to go on this lawsuit, and that means that she becomes complicit in this whole episode. So the lawsuit is based on First and Fourth Amendment claims and criminal procedure claims. And there is a procedural statute, which I'm going to show you. It's called 41G. There's several different things. Everyone knows Fourth Amendment is unreasonable search and seizure, but they make a First Amendment argument as well. Well, the reason that they make this argument is they claim that, well, now the FBI can link ballots to voters because they have all the election records. Well, first of all, number one, that's another lie, because there is no link from a ballot to a voter on the election records. And if it was true, then Fulton County has been violating Georgia constitutional ballot secrecy for decades. So not only they're lying, they're lying or they're in violation of Georgia constitutional requirements. So what's interesting about this, and we'll come back to this later, that it's included in this lawsuit is a declaration by the elections group, a gentleman named Ryan Macias. And his name will come back up in a minute. It's a name that you're going to want to probably remember. A few things. The most important thing to understand is there's going to be a hearing on Friday, and we'll see how this goes. It should be a motion hearing, but none of these plaintiffs have standing. Now, you know that I should know something about that because we won standing in the Georgia Supreme Court after a judge lied to us and said that we didn't have standing. Well, we proved that he lied, and the Georgia Supreme Court came back and said, of course, anyone has standing to sue a government agency or official who violates the law. They made that decision unanimously, and they did that without even a hearing. I was so looking forward to going to the Supreme Court and winning the Supreme Court with an argument, but we didn't get a chance to do that. It was such a no-brainer that all the Democrats and Republicans agreed who were on the Supreme Court, except for one had to recuse himself because he's the one that ruled against us in the Court of Appeals, and then he was promoted to the Supreme Court immediately after that, Judge Pinson. So anyway, here is the motion. I want to show you the Rule 41, search and seizure. Motion to return property. A person aggrieved by an unlawful search and seizure of property or by deprivation of property may move for the property's return. So the first problem is none of the plaintiffs own the property in this case. Even the clerk. The clerk is simply a custodian of the property. She doesn't own the property, and none of these plaintiffs are aggrieved by the seizure of the ballots. In fact, the clerk actually motioned in our case in June of 2024 to destroy the ballots because she said they didn't have room for them. So she wants to destroy the ballots, but then she says, no, the FBI can't have them. So you can see the hypocrisy and the corruption that is in Fulton County elections right now. And now it permeates all the way up through the commission and all the way over to the clerk. We know that nothing can be trusted in Fulton County. And these are the officials who are blowing our taxpayer money big time trying to hide these ballots to the tune of tens of millions of dollars, hiding them from the voters of the state of Georgia. So a couple more things. In addition, were they not aggrieved, governments and their agencies don't have any constitutional rights. The rights under the Constitution are reserved to the people. The United States citizens have constitutional rights. Fulton County doesn't have any, and neither are the other government agencies within Fulton County have it, and nor does the chairman or the clerk, because they're operating in their official capacities, not in their individual capacities. So they don't have any standing. And this is probably the biggest no-brainer case I've ever seen. And it'll be interesting to see what happens on Friday if this hearing goes forward. The U.S. Department of Justice has already asked for the hearing to be vacated because there's no one who has standing, and there's no point in having a hearing that will allow a fishing expedition as to what the evidence is to criminals or potential criminals. Why would you be conducting an evidentiary hearing for plaintiffs who have no standing? So that's the hypocrisy of what we are facing on Friday. We'll see how that goes. The judge may decide to either cancel the hearing or reduce it to a motions hearing, which would make some sense. But we'll have to see how that goes. That'll be Friday at the federal courthouse, Richard Russell Building. Judge Boulay will be conducting the hearing. I don't know what floor that's on, but it's downtown within walking distance of 5 Points if anybody's interested to come. We'll be there for sure. So let's talk about the probable cause. They claim that the FBI does not have any probable cause. Well, look, if you have followed elections in Georgia for the last few years, you already know this evidence because it's already public record. In fact, we have folks in the room that have helped produce a lot of that evidence. So one is missing digital records. This was admitted in a state election board criminal referral just recently. The Fulton County, and you've seen this on social media, admitted in a complaint brought by David Cross that they had no unsigned or missing tabular tapes for 315,000 ballots, which represent all of the early voting. So that has been admitted. So that's obvious probable cause right there. Then you have the vote count discrepancies that existed. And this was proven out by Governor Kemp's own report, which was based on evidence that we had assembled. Again, David Cross and Joe Rossi took this to Governor Kemp's office and got Governor Kemp to write a report that confirmed what we had already said. This was already back in 2021. I think we had re-released it in July 13th of 21, and then the governor released his report in November. We also know that Fulton County was notified of these mismatches, and we'll show you that in just a second. There were double scanned ballots. How do we know that? Because we had state election board expert witness testimony from Philip Davis on July 9 of 2024. And he testified that 3,930 ballots were double scanned. And that was just in the recount. More of them were double scanned in the original count. We'll show you that. Then you had counterfeit ballots. I happened to be there the day that the counterfeit ballots were found on November 14th of 2020. That was during the hand count audit when Susie Voles and others found the ballots, the infamous mail-in ballots. They were mail-in ballots. I know that Fulton County is trying to claim that they were not. They were mail. They were in mail-in boxes. They were not folded from being mailed. They were not written with a writing instrument. They appeared to be toner copied. They were not on the correct paper stock. And they were voted the same way down ballot dozens of a row. Clear counterfeit ballots. The witnesses all signed 6 sworn affidavits. This was 4 senior poll managers and 2 audit monitors. All signed sworn affidavits, seeing them. Again, I was there. They presented these to the elections official. At that time was Nadine Williams, who's now the director. And there's no provision in the state of Georgia for what to do if you find counterfeit ballots. And that's a crazy situation, but there isn't. So they were told to just keep on counting because they had nothing else to do. Then finally, and I think this is the most interesting thing, we won't go too deep on this one today, but you'll be hearing more about it, I think. Unsourced ballot batches. So after the system, after it was certified, after the election was, the certification deadline had passed on December 2 of 2020, nothing matched up. And we'll show you a little bit of that. And there is still no excuse for how they were able to reconcile the number of votes they published with what the batches, they were off about 16 or 17,000. I'll show you that in just a second. So that was the evidence that the warrant was based on in general. As you can see, all of that has probable cause for a criminal investigation, despite what any highfalutin Washington, D.C. lawyers claim when they're coming in here to try to represent Fulton County on our dime, our taxpayer dime. So we've been hearing that the election results added up. We've heard that you've had 3 counts, they've all matched. That's another lie. They never match, nothing matched. Here are the actual results from the Secretary of State's office along with the investigations. Here are the counts. These are the official counts from the Secretary of State's office. And as you can see, nothing matched. Nothing matched. They're off thousands of votes. In fact, the audit is off by over 10,000 votes from the original count because thanks to David Cross and Joe Rossi, they found 6,691 double reported votes in the audit. 6,691. And there's also, as you can see, a 3,466 vote difference between those. So that's a 10,000 vote discrepancy between the audit and the original count, and they told us they matched. The Secretary of State has continued to tell us they match. They don't. These are his numbers, and this is the Governor Kemp's report. It's not even our information, even though we originated a lot of it. There's also, according to Secretary of State's own reports, a 4,880 vote discrepancy between the machine recount and the original count. That didn't match either. That's 15,000 votes there that would generate an automatic new election because the margin of victory was only 11,779. Anytime there are more votes in question than the margin of victory, the candidate is entitled to a recount in the state of Georgia, and the president never got it. So, but it doesn't end there. None of the 3 counts match with the number of voters who voted. That's right. And this one, we owe thanks to Jason Frazier for this one, 516,000 voters who voted. So that's an 11,708 ballot discrepancy between these two numbers. This was supposedly, the recount was supposed to be the final number, but yet there's 11,708 more ballots than there are voters who voted. Now, in addition to that, Jason also found that there were another 166 voters who were credited for voting twice. So how does that happen? They either had duplicate registrations, or some were credited for voting both in early voting and on election day. It's not possible. So who cast ballots for these voters? Did all these voters vote themselves twice, or were ballots cast for them? You would think that Fulton County or the Secretary of State would be interested in finding that out. They're not. Therefore, Jason has filed State Election Board complaints to try to get to the bottom of this, because the State Election Board right now, after being reconfigured, is really the only election entity of any kind that we can trust in the state of Georgia. I mentioned to you before that Philip Davis, who is a 30-year career image analyst and has a site called ballotassure.com, produced a ballot integrity analysis. He found that, as I said before, 3,930 double scanned votes were double counted. The reason we know that they're double counted is because all the cast vote records were certified. That's how we know that. The Secretary of State's legal counsel, Charlene McGowan, withheld that information by the State Election Board. That broke the trust between the Secretary of State and the State Election Board. They called in 3 expert witnesses at the following meeting, which was in July that I mentioned earlier. That Charlene testified in May. And they found, this is what they found. In addition to the 3,930, though, in recount, that was in the recount, 470 were double scanned and double counted in the original count. And that doesn't include the mismatches. So what Philip found, he's got a fascinating little slide I was going to put in for you. But the 5,812 original ballot images were missing in the recount, and 1,330 were missing in the original count, the recount. So nothing matched. They had ballots one way that were there in the recount and that were gone in the original, and vice versa. Nothing matched. I mentioned the counterfeit absentee ballots. I think I've already laid that one out for you. Again, I was there. I was a witness to the whole thing where I was coordinating the audit monitors that day on the floor. It was an amazing day. Even rode with Susie up down there and back. So before I get into the missing records, here's the thing that we need to understand. This is the next one we want to go to. So here's how they certify an election in Georgia. You have a physical ballot. The ballot's scanned. It produces a ballot image. Then it's tabulated if it's in person, and that produces a cast vote record. If it's an absentee ballot, they accept the batch, and that produces the cast vote record. So I left that one off. Probably should have put it on. And then the cast vote records are aggregated, and you get the statement of votes cast, and you get the published results. So along that line, when the ballot's scanned, you get an entry into the slog files. The slog file is a scanned log file. You get a TIFF image for that ballot. A lot of you might be familiar with the tagged image file format. It's just like a JPEG format. It's just a different format. And each of those has a SHA authentication file. So the SHA authentication file is like a signature file that verifies that this TIFF image is correct. If the TIFF image was changed, you would rerun your little algorithm and you would get a different number. You'd know that the TIFF image was changed. So that's the purpose of the SHA file, and then you got the cast vote record files. So that's the way those are the files that should be retained. But here are the files that were missing. Virtually all of the scan logs, as we can tell, were missing. They don't have those. And they're missing over 1 million of the ballot images, not just the 315 or 16,000, but they're missing quite a few others. That, for example, in the recount, they're missing 17,852 ballot images. This is well known. we found this first. Again, that's another more work with David and the team back in July of 21. But so you can't have a certified vote without a ballot image. See, because this is the way it works. And they can't change that. You can't have a certified vote without a ballot image. It's not possible. The image had to be created because the image is analyzed to produce the cast vote record. So you have to, it's a 1-to-1-to-1 basis for those of you who ever did computer data analysis. So we talked about that. Then the last thing I wanted to talk about was the post-certification ballots. This is very interesting because, and the certification deadline, Fulton County had 511,543 ballots, according to their batch upload report. And Richard Barron sent that batches loaded report the next day because they were ordered to reconcile because that number of ballots don't match the total that they reported. They reported 527,000. So where are the other 16,400 votes? So it didn't match up. So he sent this over to the elections group, Ryan Macias, and they get to back and everything matches on December 4th. So that's quite interesting. I'm sure we'll hear more about that. But one of the things I wanted to mention to you earlier, I should have. So while talking about the audit, Joe Rossi showed this in his state election board meeting, the meeting before last. Here's proof that Fulton County knew that the audit never matched the original count. This is a letter from the elections group, Mike Prendergast, telling Nadine Williams that there are errors in the audit reporting that need to be fixed. And a lot of the errors, and just a subset of them, are the same errors that Joe and David identified in their analysis back in 2021. This was in November 19th of 2020, so they knew within days after the hand count audit that it never matched up. And they were informed that by the elections group. So this is interesting. So who is the elections group? The elections group, I think you're going to be fascinated to find out. They were overseeing logic and accuracy testing, signature verification, hand count audit reporting, and the post-certification reconciliation I was talking about, all without the knowledge of the Fulton County Board of Elections. There was a deal cut between the county manager and the elections division, and they circumvented the Board of Elections. Board of Elections didn't know about that. And it's interesting because all these things that they were overseeing had amazing problems. The logic and accuracy testing we now know was not performed for early voting because they had computer problems and they couldn't even get stuff working on the BMDs before early voting started. So they were literally doing LNA testing later after it started. The signature verification we know was not performed by the election board's members have testified under oath that they were told that it was not performed. We know that their Blue Crest machine was not working. And only, according to EAC statistics, only 6 ballots were rejected when normally out of 148,000, they would be rejecting 3,000 for signatures. So nothing going on there. And then hand count audit reporting, we talked about the massive discrepancies. There's also a chain of custody issues in that Fulton County would not allow us to view the data entry point. So they were entering the data for the tally sheets during the audit. That was going up to the Secretary of State's office. Nobody saw what they entered, and they said, well, if you want to know what we entered, ask Secretary of State. So Fulton County and other counties the same way didn't even have knowledge of their own audits and their own results. And we talked about the post-certification reconciliation. Election groups, again, operating without the knowledge of the Fulton County Board. So what is the election group? So I thought y'all be interested to know this. Election group was funded by the Center for Technology Civic Light. You know a little bit about that, CTCL. Spent $45 million here in Georgia. 94% of that county monies went to counties won by Joe Biden. CTCL funded $330 million of Zucker bucks for CTCL. And the purpose, there were three purposes according to their agenda, their agreement, their memo of understanding. They wanted to install outdoor drop boxes. We know how unsecure those turned out to be, and they're now been banned in the state of Georgia. And they wanted the counties to use it for partisan get-out-the-vote efforts. You know, the get-out-the-vote efforts is partisan if you're spending 94% of your money in counties one by one candidate or the other. And then they also wanted to provide complementary resources to run county voting systems. This is all in their agreement. So who was CTCL? This is not a nonpartisan group. This is a highly partisan group. CTCL was funded by, as y'all know, Mark Zuckerberg. And Mr. Zuckerberg installed a policy director, David Plouffe, who is the former Obama campaign manager who wrote the book, A Citizen's Guide to Beating Donald Trump. That is why you do not want private money in public elections. So, thank you. I think I'll stop there. Do you want to do the last slide? Where are we?
So the saga continues. Obviously, maybe we're finally getting to the end or close to it. So to take away today, the state election board will investigate the open records request false claims and evaluate Garland's recommendation to fine Fulton $10 per ballot per instance with referral to the U.S. attorney. That adds up to a lot of money. Then Fulton County lawsuit that's opposing the DOJ must be dismissed because none of the plaintiffs have standing. So keep your eye out for Friday. Let's see what happens. The FBI had more than enough evidence to support the search warrant, regardless of what you hear coming out of the Fulton County officials. And then finally, the FBI will be able to conduct a thorough criminal investigation because I think we're to the point where it's obvious what the evidence is. Now the question is, were they hiding criminal activity? And I think it's time to find that out. So, what a story. So I'll just take a couple seconds here and talk about VoterGA. If there's anyone that is not familiar with us, VoterGA has actually been in existence since 2006. Garland and a co-founder, Ricardo Davis, founded it. And it was kind of a small operation until 2020. And after the 2020 election, so many people got involved in trying to get to the truth. So what we have going on now is a federal lawsuit against the Federal Election Assistance Commission to vacate Dominion Voting System certification. We have evidence that it never should have been certified, and we're hoping that we'll have a hearing on that next month. We also have several other active lawsuits. I'll just mention a couple. The Fulton County counterfeit ballot case is now on appeal. After being out there for 5 years, after the FBI came in, the judge dismissed the lawsuit and said we needed to pay Fulton County's attorney's fees. So of course we're not going to do that. We have appealed it, so you'll be hearing more about that in the future. And another case that we have, which we still have not gotten a hearing on, is our Salesforce case. All our voter registration information is held in the cloud, and that is very unsecure. Salesforce has known to have been hacked in the past and not even told their clients. So we sued to bring that back in-house to the Secretary of State. So we'll keep following up on that one. We also have a project going on right now where we have, under open records requests, we have requested ballots from several counties around the state to see the 2020 and 2022 election ballots. So we never could get them out of the courts, so we are doing it under the new law that Garland talked about that was effective January of last year. And then, of course, we are always down at the legislature advocating for more election integrity bills. The Georgia legislature is in session right now, actually until just April 2nd. So we are trying to get more bills passed that will make our elections fair and transparent. Also, education is a big part of what we do. So we travel around the state, speaking to voters, to civic groups, to make sure people know how to get involved and understand what's going on. We do lots of poll watcher training. I think before the 2024 election, I trained several hundred poll watchers throughout the state. We also offer free nationwide expert witness testimony for a lot of the lawfare that has been going on. And then we hold press conferences like this. And finally, we're leading the fight nationally to support President Trump's election executive orders because we believe it is so important that we hear from him. And here's how you can connect with VoterGA. We're on all social media platforms. It's just @VoterGA or #VoterGA. We are a 501c3. All donations are tax deductible. And you see this graphic up here. If you go to voterga.org to the donate tab, you'll see the same exact graphic. Click on it and it will take you to a link that has apparel, Make Elections Great Again apparel that we give as gifts for donations. And if you're here in the room, we have some on display up here. So I think with that, we will go to questions. We will start with media in the room. Well, let's go back here. And then go online as well. And as I said at the beginning, if you are watching online and you have a question, go to either Rumble or X, and we will ask Garland your question. So I'm going to go back over here and monitor the chats, and Garland will come back up so he can answer your questions.
All right, thanks. While Tamara's checking the chat, we do have a media or two in the room. Is there any question that y'all would like to ask about what was presented today? Good. Okay, thank you. Tamara, do we have anything in the chat yet? But I'll just go ahead and start with the room.
Why don't you do that?
Okay. So starting with the room, any questions about what was presented today? I know there's a lot of other issues out here, but we have to kind of leave it. I'm sorry. We want to ask for a mic. Hold for the mic, and so we can get this.
The data you provided was perfectly clear. I believe every bit of it. You have confirmed it all. What's the likelihood you think we're going to get consequences of criminality and prison time?
I think there's an extremely good likelihood that we're finally going to get accountability because we've spent 5 years with people covering up the crime. And these are people in official positions, the Secretary of State, the Attorney General, you saw Fulton County. All what we're looking for is just show us the ballots. Ballots should belong to the people, not to a government agency who wants to put whatever results they want out there and then hide the ballots to us. So I think I'm very optimistic about what's going to come out of the FBI investigation. It's obviously they're conducting a criminal investigation. They would not have done what they did, gone into search Fulton County, if they didn't have the evidence. They have a wealth of evidence. If you just took the evidence that we put out for the last 5 years, you've got there's so many civil discrepancies that it'd have to justify a criminal investigation to determine whether or not there's criminal. So I think we're going to see some, now, in fact, I'm going to go a little bit further. Now you've got the issue where the cover-up is worse than the crime itself. You have gotten, so somebody cheated on November of 2020, somewhere in December, in all likelihood, but you've got this massive cover-up that's gone on for 5 years. And I would argue that the people who have covered this up for 5 years are worse than whoever performed the deed in the first place. And I have to also include in that certain news media stations who have, or not stations but so much, but just AJC has been very, very complicit. GPB has been complicit in all this, and a couple of the news media folks, and that's just in Georgia. I don't want to get into the New York Times, the Washington Post, and all that stuff. So anyway, anybody else have a question? Looks like we got over here on Janelle. So he's got that great sweatshirt on. I love so much.
Okay, my question is about intent. Can you prove intent that they did not train the people who left their signatures off of all of those tapes for a reason? Can you charge for intent to cover up? There's like 40 million ways of intent here. It's like death of 1,000 cuts here for intent. So we're bound to be able to get somebody for doing all this stuff.
Well, the question is, was it an accident or not? So as the Secretary of State...
I want to speak to that.
The Secretary of State, I'm going to, I'm going to speak to that. The Secretary of State claims that it was a clerical error. And... that 315,000 missing signature or missing tabulated tapes was a clerical error. Obviously, that's a lie. You could have one or two missing or tabulated tapes. I'm sure, David's here. I'm sure he would agree. He brought the case. So, but 315,000. All right, and then on top of that, you hid that for 5 years and pretended that you didn't have it. That to me is pretty obvious criminal intent. I'm not a lawyer, but so I can't really say for sure, but it's pretty obvious this was no clerical error. And the fact that the Secretary of State would even say that is laughable.
If I may add to that, there's a huge poster at the tabulating machine that says, "Sign the tape." When I was a poll worker, I was trained on the poll pads, and I still knew when that tape came out and said, "Please sign here," to sign. So this clerical error, I'm just laughing. There's poll workers are not that dumb.
Exactly. And there was a reason, maybe they decided to close them out on a different machine and that kind of thing. There's also, maybe there's a legitimate excuse, but I doubt that. Very serious. And since you brought it up, I have to mention, particularly for the folks that will be watching this nationally, on the Dominion system, the tabulator tapes, when the poll worker signs the tabulator tape, they're signing an oath to the Local Election Integrity Act. As you know, that Dominion is a Canadian-based manufacturer, and that act is a Canadian law. It is not an American law. So when they sign that, they're signing an oath that they're certifying according to a foreign government act. And that is true with every Dominion system, democracy suite system that we know of. And that is the plan. They're going to use these systems again in the 2026 election. That's just only one small reason of all the reasons why we have a federal lawsuit to vacate that certification immediately. And hopefully we'll get a hearing on that within the next month. Any other questions? John's up front. Well, okay, we got two in the chat while you're getting the mic.
Okay, so this question has two parts. What are the implications of all of this to other states? And then the second part of her question is, beyond people acting in questionable ways, are the machines being scrutinized per intent?
Yeah, so let's start with the first one.
I'm sorry about that. What are the implications for other states?
Oh, the other states. The implications for other states. All states should have ballots as public record. That is the number one thing. If you've got ballots public, and they should be immediately available upon conducting of the election. I'm not talking about ballot images, the actual physical ballots, because the ballot images can be electronically altered. So that the first thing that I would do if I was in another state is I do what we did for 4 years to try to position the legislature and lobby them to make ballots public record. So we got that, and we're one of the only states in the union that has ballots as public record, and it took us 4 years to get them. So that's the first answer to the first part of the question.
So in the second part of the question is, beyond people, are the machines being scrutinized for intent? Interesting question, huh?
Well, no, they're not being scrutinized, and that's the problem. As you saw here, and this is a great question, as you saw here, the electronic results were altered. We talked a lot about Fulton County ballots and being stuffed and the counterfeit ballots and everything, but it appears that the electronic results were altered to make everything match up. So that could have been an inside job, could have been an outside job, remote, but it's very likely that you've got to protect yourself and your machines from being manipulated internally. So both internally and externally. So that's another major consideration, because even though we don't have any evidence of remote manipulation per se from a foreign country, we still had electronic vote manipulation right here. And I don't think people understand that, how risky it is to have electronic vote manipulation even as an inside job. And it's very easy to do, because all you do is create the cast vote records you want to certify. As you saw, nothing matched up, but yet suddenly they matched up, but yet they didn't scan any more ballots. So I think that would be my answer to that one.
So last question. Will you file an injunction to ban the machines? It says based on the DeKalb County recount evidence. I think they meant Fulton recount evidence that you went through.
Well, we currently have a lawsuit to vacate Dominion certification, which would effectively ban them, because the state requires that the system be certified by the EAC. So if we vacate certification, the state's going to have a real problem explaining how they're going to use this. Even to a corrupt judge, we might end up with in a state court. So, but fortunately, we won't have to do that. We maybe can go into federal court and avoid the state courts altogether. Because one thing we have learned is we waste a lot of time and money in state courts. A county superior court is not going to rule against the county. So yeah, we should be able to do that from a state perspective.
The state, Michelle Long Spears in DeKalb County. She that may be the reference for DeKalb County.
Oh, could be
Oh,
that recount. But I think it's the same answer.
okay, yeah, it's the same answer. You're right, because we would not need to do that because we already have one going right now. And as we have a very clear cut case in this. It's going to be very difficult for them not to vacate the whole thing, the whole deal there with the system. And by the way, why is it that we're having to spend money to vacate Dominion certification when the president issued Executive Order 14248, March 25th of 2025, to tell the EAC, Election Assistance Commission, to vacate or to decertify all QR-coded voting systems, which that includes not only just ES&S, but also the Dominion Democracy 5.5. So we're having to spend our taxpayer money. They're having to spend our taxpayer money to fight not to do what the president ordered them to do almost a year ago. That is a level of hypocrisy that is just beyond me.
John Evans. So I understand you won the original petition to see the ballots, and then it got thrown to the Georgia Supreme Court, which you won, and it came back. Shouldn't you immediately get the ballots?
Yes.
Except for the judge spent 3 years doing nothing, apparently.
Yes.
Is there anything you can do against the judge?
Yeah, I don't know if judges can be sued for bad decisions, but this would certainly be the poster child case if you could do it. But this is a great question. It's got a long answer, but it's a really worthwhile answer. So when we got the case back from the Georgia Supreme Court, that activated the preservation order and the unseal order. We were good to go. At that point in time, we should have immediately opened discovery and gotten the ballots. That was in December of 2022. However, it took a few months for the Court of Appeals to remand the case back. They finally remanded the case back on, I believe it was May the 11th, hope I got my dates right, to the Superior Court. And what we found out was that the judges had been in communication with one another before that time to hand that case off to Judge McBurney, who we knew was just not going to be an honest judge in regards to any election matter. So what?
Recuse himself.
So we filed a motion to recuse Judge McBurney, and in my opinion, an honest judge would have just recused himself, but instead, since he apparently had some kind of a vested interest in ruling against us, which he demonstrated in the David Perdue case. So the reason we filed that motion to recuse is that he made what we call extrajudicial snide remarks about Senator David Perdue's case, which was very similar to our case. So we knew that he was partisan, but then we filed the motion to recuse, but another Fulton County judge said, oh no, you don't, that's just garbage. He can stay on the case. So here we got one Fulton County judge covering up for another Fulton County judge, covering up for the Fulton County election officials. That is the massive amount of corruption there is in the Fulton County judicial system, which we have personal experience with. So Judge McBurney then had one hearing where the Fulton County, this is a true story. You can't make this stuff up. So the clerk goes up in June 24 and she says, we want to destroy the ballots because we don't have room for them. Now, this is after they had just purchased a 660,000 square foot warehouse that you saw in the picture, and you only saw a small part of it, a quarter, And they're telling the judge with a straight face they don't have room, they got to destroy the ballots. And the judge, to his credit, said, well, aren't there some other preservation orders already on this? And yes, they were. So he couldn't order them to destroy the ballots. But at the same time, they requested attorney's fees for us winning the case in the Georgia Supreme Court. And I'm sitting here, so we sent out a press release on how ridiculous that was, and then we find out that the absurdity, the Judge McBurney rules against us and says that we have to pay attorney's fees. After we had won 5 rulings, preservation order, unsealed order, we got the ballot images unprotected at the lower court, we won all the way to the Georgia Supreme Court, won all the way Court of Appeals, and McBurney, with a straight face, writes and says that we had no legal or factual basis for our case. No legal or fact. I mean, every judge that's looked at it has agreed, even if they ruled against us, has agreed that we had a factual basis for the case. We have a proven track record of 5 years of legal and factual basis for our case. So that's why we are appealing. And I'm sorry to go off on that tangent, but you twisted a bit. So go ahead. You got me going.
So after, a couple dozen people go to jail for all of this, and the ballots come back, and if they won't give them to you, will you volunteer to destroy the ballots for Fulton County and charge them for it?
Now, I thought I would frame them and put them in my garage or something. I don't know. No, I think, you know what I think we should do? I think we should get some space here in the Computer Museum. And these are the famous Fulton County ballots. We'll seal them all up. There's a lot of material in that cage that they took. So, but I think that will probably go down in history when all this is over. So we'll have to preserve them in a museum like this place.
We're going to put the Dominion machines in there too?
We're trying to get the Dominion machines in here in the museum. This is the best place for them. They really should not be used in elections for many, many reasons that you can read about in our court case, including not having a legitimate certification, which we provided through expert witness testimony and so on.
Okay, I'm not in Fulton County, and I just saw one of the representatives, I think her name was Miss Draper, talking about how Fulton County affects all of Georgia. Is it possible for all of the good counties that did everything right, no clerical errors or anything, to sue Fulton County for affecting all of Georgia?
Oh, that is a great question. They certainly did that in Arizona. They do have the right to stand up for their constituents. That is such a good question, and I don't have a good answer for it. But to your point, Representative Draper did say, and this is probably the only thing I've ever agreed with her on. She said, whoever controls Fulton County controls the state of Georgia's elections. She said point blank. And that is what this is all about. Whoever controls Fulton County controls Georgia elections, and that is why they have fought for 5 years to prevent us from seeing the ballots, because they want to control the state elections. And Fulton County has 10% of the vote. I mean, otherwise this would have been over in 2 months, 3 months after we filed the lawsuit. This should have been over 4 or 5 years ago. Any other questions? All right. Well, thank you for coming. We really, really appreciate it. A hearing Friday, if you're going to come at Richard Russell Building, 9 o'clock. We'll see you there. And thanks, everybody, for coming out. Hey,
We
got
can't,
one more.
we can't end a press conference on election integrity without talking about Tina Peters. Boy, you really
I
wound us
always-
all the way back up.
I forgot. My bad. I'll get this up for you.
Okay. So Tina Peters, for anybody that may not know, was the Mesa County, Colorado clerk in charge of all of the elections in 2020 and 2021. She has been prosecuted and is serving a 9-year sentence for very technical charges around observance of the Dominion upgrade that was done in May of 21. She is a 70-year-old grandmother, a Gold Star mom. Her Navy SEAL son was killed in a skydiving demonstration in 2017. She is a cancer survivor. But even if she was none of that, if she was a 35-year-old healthy individual, what has happened to her would be horribly corrupt because she is innocent. She has been in prison now for 500 days. So we have a video made by one of our very talented volunteers to mark the day that she spent in prison. Get this going. Do we have sound?
No audio? Okay. All right, well, let's start that over.
Okay. You want to start it over for me?
Yeah, I'll start it back over. Yeah, I'm pretty sure I do.
Well, check that. We tested this earlier and the video's fine.
All right. Audio is almost totally up. We'll go all the way up with it. Do we have, you have audio on the?
Yeah.
Audio is up on there. Okay, let's.
I may blast us out, huh? Do what?
Incremental steps. Are you planning to?
No, press it.
How do you even mute it?
Let's try this. Okay, there we go, 60. That should be about right. All right, let's try this again. We're going to go one more. This is just a 2-minute video.
Yeah.
Oh,
There you go.
is it back up? Okay, now
Yeah.
we're going. Okay. Little 2-minute video that we put together, and I think it's pretty touchy. 500 days.
So the audio is not going to the TV from the computer. We tested this earlier when we put that on it. So
All right.
route the audio from the computer to the
Why don't you
I have to worry about it.
tell her? Okay, why don't you do the backstory and let me try one last time.
Okay. So Tina was tried in 2024 in what is just a sham of a trial. The prosecution presented their case in 6 days, and Tina was given 1 day to present her defense. So totally unfair. Then she was sentenced on October 3rd of 24, and the judge basically said she was a danger to the community because of what she was saying about the election systems and the problems that she had found. And he denied her bond, even though her case was on appeal. This is unprecedented for a first-time offender. to have to go to jail, especially for victimless crimes. So here we are, 500 days later, beyond 500 days now. Her appeal was heard the middle of January, and it was very obvious in the hearing. There were so many errors in the prosecution. We talked about this at our last press conference on January 14th, or January 19th. January 14th was the date of her hearing. So if you're interested in seeing the details, you can go back and watch that. And now we wait. The 3 appellate judges seem to really understand the errors that occurred, and but like all judges, there is no time frame. Somebody told me they heard Peter Tickton, which is one of her attorneys, on a show earlier today, and he said he believed that they are really putting a lot of time and effort into this, so he was positive that this was going well for her. So we pray that she will have extreme favor with these judges. I think they understood that she's not healthy. It's not been good for her to be in prison, and that she may be locked up while they're deliberating whether or not to vacate her convictions. So that's where we are. Are we going to be able to play this or not?
I think so. Let's get
Okay.
this.
Get audio there. We'll get audio there.
All
Okay.
right.
The audio from the computer to the right thing. It should be called something encoder.
Yeah, we got it. Oh, I can't advance. Let's see what we got.
Or we can play it so that the headphones.
All right, we're going to have this in about 10 seconds. Let's see what we got this time.
Imagine.
Okay. I'm sorry. don't
You
to
have
do
no
it right.
criminal record, but were charged and convicted of victimless crimes while your
Oh,
Are you guys not hearing it on TV now?
no.
Did you? We'll pretend like it's you.
Yeah.
You have to be turned up and unmuted for the audience.
Oh, we're not going to hit in the room. That's okay. We'll have to-
All right. Sorry about this, guys.
Yeah, okay. That's the most important.
You'll have to.
Unfortunately, it's only 25 people in the room, and there's like 25,000 watching.
So go listen on the archive.
If y'all want to hear it, we'll play it.
That's probably. You don't have a right. He says.
Am I cut off?
We got.
Am I cut off?
Just don't talk. Let her roll.
Oh, okay.
Should be
they're
done. Is it done? Well, is it done? We're live, so I'm going to cut this off live, and then we'll play it for the folks in the room, right?
Okay.
So
Yeah.
thanks for,
And then I'll end in prayer here.
yeah, and you're going to end in prayer.
We cannot have a press conference without praying for Tina, so please join me in prayer. Father God, we know that you are a good God. As I think I say every time, regardless of circumstances, we know that you are a good God, and we know that you hold Tina in the palm of your hand and that you have a plan. Father, we ask for extreme favor with these 3 appellate judges as they're deliberating her case. Father, I pray that the truth of the corruption would be evident to them and that Tina would be completely vindicated. And Lord, I ask that while she's still in prison, you station your angels around her to protect her. And we thank you that you are using her right where she is, regardless. We love you and we praise you. In Jesus' name, amen. Thank you for joining us today. We look forward to seeing you next time.